Good afternoon, everybody, and welcome back to our Friday afternoon webinar. I'm just going to give our attendees an opportunity to join us. I can see the numbers going up, so while they are getting themselves settled in with a nice cup of tea to listen to what I've got to share with you today, which is, of course, the employment law update. There's lots of updates coming in force and effect from April, and of course, our Friday afternoon webinars will not be the same without a COVID update. And of course, there's lots of information to be sharing with you. So, you know, for those of you who are familiar with me, it's Angela Clay, an HR and employment law solicitor, and today is Friday, the 26th of February, 2021. Can you believe it? We've been here for such a long time, coming to join me with these webinars. So for those of you who are new to the webinars, HR for UK, who are we? So HR for UK is a leading provider of HR and employment law matters. We also provide of course we provide HR support, but we also provide payroll and pension support and also health and safety. We've got over 30 years of experience and we've got some fantastic 5-star reviews. And I would encourage everybody to go to our website, which is www.hrforuk.com, to have a look at those 5-star reviews for yourself. So as you can see what our clients say about us rather than me telling you about what we can do for your business. So of course, as I mentioned, I am Angela Clay as an HR and employment law solicitor. I'm the Managing Director of HR for UK, and I'm responsible for HR for UK's role as a leading professional in HR services for UK businesses. And I've said this right from the beginning, and I'll continue with it, although there does appear to be light at the end of the tunnel. But my vision for your business is to successfully come out of this coronavirus crisis successfully by offering you clear, practical, professional advice and support. No matter what your question and query is, we will be able to help you and support you and make sure that we're going to keep you on the right side of the law. So today we've got quite a few things that we're going to be covering. We have two key areas that we're going to be covering. Of course, there is the employment law update, and then of course there is the ongoing COVID questions that are coming in. We've already got some questions that have come in. Linda Edwards, well done. You are the first person today to put some questions in. I promise I will get to those questions as soon as we get the webinar going, and I will answer those for you as soon as we can. But let's just have a quick look at what we are going to be covering today. So today we're going to be having a look at those employment law updates. Particularly, we're going to look at the national minimum wage and the national living wage increases that come into effect. There is also the statutory payments which increase in April. We're going to have a look at the gender pay gap reporting requirement, payroll implications and HMRC risks to avoid. Of course, there is life after Brexit, what new rules have come into place. I'll be pleased to report that there aren't any new ones that have come in, but just a reminder on the implications of Brexit. Having a look at IR35, are you prepared for those IR35 requirements from April 2021? And then, of course, with furlough, we're going to be having a look at the latest, of course, is the government going to be extending the furlough scheme? Is there going to be an extension? What is that extension going to look like? If I had a crystal ball, I will be able to tell you, but all will be revealed when the Chancellor reveals what his plans are in his budget next Wednesday. So we will keep you up to date. Of course, these webinars are only as good as they are for you. If you ask questions, for those of you who are familiar, there is the opportunity to ask questions on the right-hand side of the panel. Please do ask questions. They don't have to be related to today's webinar. It can be any questions that you may have. If we run out of time, don't panic, don't worry, because we do collate all those questions and we circulate it to you as part of the recording of this webinar next week once we have got all that together. I love getting the questions. I love being able to answer those questions, so please do let them come through. Just a reminder, this webinar is being recorded, and the recording together with the questions will be made available to you next week. And of course, we will be looking forward to making sure that we hear from you in relation to what you want these webinars to cover, because as I've already said, these webinars are only as useful as what they are to you. I can come up with all sorts of topics which may not be relevant to you. So I'd love to hear from you to be able to tell me what you would like me to cover in future webinars. So without any further ado, I have got so much information to share with you. I know I normally say that we're going to be here until 4 o'clock. I will do my very best to get done by 4 o'clock, but those of my regulars who know me will know that I'll probably go over. I won't be offended if you need to leave at 4 o'clock, but those of you who can and want to stay on until I'm finished, of course that would be great, but don't worry, as I say, you will get a recording of this webinar. So let's have a look at what changes are coming in force. So statutory rate of pay, national minimum wage, national living wage increases all take effect from April. So let's have a look at the statutory rates of pay. So these include statutory sick pay, maternity pay, paternity pay, adoption pay and shared parental leave, as well as the maternity allowance for those who don't qualify for maternity pay. These increases usually occur on the first Sunday in April, and this year that will be with effect from the 4th of April. The new rates to statutory sick pay will increase to £96.35 per week. Do remember that statutory sick pay is up to is a payment for up to 28 weeks for an employee who is too ill to work. Of course, if an employee doesn't use up the entire week, you can use the daily statutory sick pay rates if your employee isn't off for the whole week. Turning to the statutory maternity, paternity, adoption and shared parental leave, parental pay, together with the maternity allowance, this is going to be increasing to £151.97 per week. Of course, for statutory maternity pay, this is paid for up to 39 weeks, but don't forget that this is 90% of weekly earnings before tax for the first 6 weeks. Thereafter, it is £151.97 or 90% of your average weekly earnings, whichever is the lower, for the remaining 33 weeks. The same applies for shared parental pay, but of course with shared parental pay, this is for a maximum of 2 weeks, which can be taken in blocks of a week or 2 consecutive weeks, and this is at the flat rate payment of £151.97 or at 90% of your average weekly earnings, whichever is the lower. So quite a mouthful there, but don't worry, we will make sure that you get a communication out to keep those rates at the forefront of your mind, or for you to hand over to your payroll team. So let's have a look at the national wage, get back to it. So let's have a look at the national minimum wage and the national minimum living wage. I put my teeth in. So the UK government has accepted the Low Pay Commissioner's recommendation to increase the national living wage and also to increase the national minimum wage, and these rates will apply from the 1st of April. So for those who are aged over 23, yes, there has been a change in the higher age in terms of national minimum wage. Anyone who's over the age of 23, their national wage will increase to £8.91 per hour. Between the ages of 21 and 22, this is going to increase to £8.36 per hour. For those who are between the ages of 18 and 20, the hourly rate is going to increase to £6.56 per hour. And those who are aged between 16 and 17, their hourly rate will increase to £4.62 per hour. Of course, it also goes without saying that the apprentice rates will also increase alongside the increases for all the age groups. But don't forget, of course, with an apprenticeship, there are different rates of pay depending on the age of the apprentice and also the year that the apprenticeship is in. So those apprenticeship rates are, for those who are 16 to 17, this is going to increase to £4.62 an hour. For those apprentices who are between the ages of 18 and 20, this is going to increase to £6.56 per hour. And lastly, but certainly not least, those between the ages of 21 and 22, their apprentice rates will increase to £8.22 per hour. There is also the increase in of accommodation offset. and that accommodation offset will increase to £8.36 per week. So of course there are implications with payroll and HMRC risks to avoid. So in order to safeguard your organisation, we would strongly recommend that you take steps now to review what your rates are going to be with effect from April, and make sure that your structure does not fall below the national minimum wage requirements. It is always good practice to write to your employees to let them know that their wages are going to change. And also, of course, importantly, is to make sure that any forms that you use when you are submitting payroll information, that these changes are also reflected there. And of course, making sure that your payroll team know of the changes. Not paying the national minimum wage could give rise to a number of issues. Not only from an employee's point of view could it give rise to an unpaid wages claim in an employment tribunal, but HMRC could also impose fines. But quite embarrassingly, HMRC do name and shame those employers who fall foul of the national minimum wage. So it's really important to make sure that you are aware of those changes and you implement those changes within your organisation. Of course, if you are looking to review your payroll services, HR for UK can take care of all your payroll requirements and needs. Switching your payroll from your current provider to HR for UK couldn't be simpler, because we do all the hard work for you. So if you want some more information about our payroll services, please do get in contact. You can either contact us through our website, which is www.hrforuk.com. You can drop us an email, which is info@hrforuk.com. Or you can just pick up the old-fashioned way of picking up a telephone and giving us a call on 01455 444 222, and one of the team will be delighted to be able to speak to you and help you a little bit more. So let's have a look at the next important changes or updates, should I say, the new gender pay gap reporting. This applies to organisations with more than 250 employees on the relevant snapshot date. So if you've got less than 250 employees, you can ignore this next bit, but of course it's always interesting to hear what some organisations have to do. Those organisations with more than 250 employees, you do need to comply with your gender pay gap reporting. So we know that it was paused in March 2020 because of the pandemic. We do know that because of the continuing effects of the COVID-19 pandemic, the Equality and Human Rights Commission has confirmed that the gender pay gap enforcement action for the reporting for the year 2020 to 2021 will be suspended until October the 5th. But that does not mean that you do not need to file your reports. So just having a look quickly, those organisations who do employ more than 250 employees at the relevant snapshot date, and that snapshot date is the 30th of March 2020, and for the public sector, and for the private sector, that snapshot date is the 5th of April. You will need to publish your report. Of course, calculations this year are going to be complicated. They will also be complicated next year because of the implications of employees who have been furloughed and who will fall under the coronavirus job retention scheme. We do know that in December, the government announced and confirmed that furloughed employees will still count towards your snapshot date for triggering those reporting duties, and will need to be included in any bonus pay calculations, but will not need to be included in the pay gap figures where they are receiving less than their full pay during the period of furlough leave. So it's really sort of knowing what your employees were doing on that particular day, whether they were furloughed or whether they were in employment. And of course, when we cast our mind back to that time last year, I think pretty much everybody was furloughed, but you need to make sure that you account for those reporting duties on that snapshot day. Let's have a quick look at life after Brexit. As I mentioned early on, there have been no further developments, which I am pleased to say. We covered this quite extensively in our January webinar, but just as a quick reminder, we are now applying the new points-based immigration system, which is in force for anyone coming to work in the UK. Of course, this excludes the Irish citizens who benefit from a long-standing arrangement that we have. But of course, as part of that points-based system, there are specific requirements that individuals will need to satisfy to score those points to be able to apply for that visa. Just another reminder, if you are going to be employing anyone who is going to be coming to work from the UK under a visa, you must be a licensed sponsor. Employers who do not hold a valid sponsorship license will be unable to hire migrant workers coming to work in the UK. Of course, just a reminder about your existing EU migrant workers, employees. They need to apply for their settlement, the EU settlement scheme, and that deadline is the 30th of June 2021. We did discuss this in quite a great detail in our January webinar, so if you have missed that, I would strongly encourage you to go to our links and to have a listen to that. But again, we reminded you of some really key points to make it easy and simple for you to be able to support your employees who need to apply for that EU settlement scheme, and how you can go about that without falling on the wrong side of the law. Moving very quickly, I think I'm doing really well today, so well done if you're keeping up with me. So let's have a look at IR35. Are you prepared for the new IR35 requirements which come into force from April 2021? Many of you will be thinking, well, what is the IR35? What does it mean? In a nutshell, it is off-payroll payments to individuals. And the purpose of the IR35 rules is to prevent the avoidance or the reduction of tax and national insurance contributions by having an intermediary between the client and the worker. These are quite controversial changes to the rules where the responsibility has been shifted, and where the contractor, instead of the contractor having the responsibility for determining their employment status for tax purposes, this now rests with the client. So that burden of proof has shifted from the individual to the client. And of course, that could have quite significant implications if you get the decision wrong. As part of these new rules, the allocation of responsibility in determining the tax status and also dealing with disagreements on how that determination is made now falls to the end user client. In addition, the new rules introduce the allocation of responsibilities for making those deductions for income tax, employees, national insurance contributions, and apprenticeship levies if applicable, and also paying the employer's national insurance contributions on the fees paid to for services to the fee payer. It is quite complex. It doesn't sit naturally within employment law in terms of employer-employee relationship, but I know many of you will be using contractors to be able to fulfill a gap, and of course you must be mindful of this pitfall. So, employers who currently engage contractors through an intermediary will need to review the arrangements that you have with them to establish whether these new rules will apply to you and what steps you need to take to ensure that you can protect your organisation. So the next piece of information I want to share with you is in relation to the employment bill. Now, I know for many of you, you must be thinking, oh my gosh, what is the employment bill? And again, COVID in 2020 really hijacked the agenda of what was important and what was happening. But if you cast your minds back to the Queen's speech in December 2019, which was talking about bringing together several measures arising out of the government's Good Work plan, they were going to be introducing a new employment bill. And this we anticipate to come out during the course of 2021. And I'm just going to move over because I can see that the sun is moving over and is catching me on my face. So I apologize if I've made you feel seasick in moving the screen. So going back to the new employment bill, the intention of this is to include the setting up of a single labour market enforcement agency. It is also to make sure that payments of tips and service charges go directly to the workers in full, rather than the employer taking some of that. It is to go to the worker in full. The request for more predictable and stable contracts after initial 26 weeks worth of service. So again, that's looking at sort of fixed term contracts to make sure that there is something a little bit more predictable and stable for those who are offered those contracts. And giving employee rights earlier than later. The Good Work Plan also included extending redundancy protection to pregnant employees, and this is to extend it for 6 months after the return from maternity leave, as well as those taking adoption leave and shared parental leave. There is also talks that this protection will trigger from the moment that they inform their employer that they are expecting, rather than under the current rules. Another piece of legislation that we are expecting to come out as part of the employment bill is a new right for parents to take statutory leave up to 12 weeks for those new parents who have whose newborns go into neonatal care. So again, that is to make sure that they get statutory paid leave up to 12 weeks. There is also talks of the rights for carers to take 1 week of unpaid statutory leave each year. And of course, this last one is going to ring so many bells and will come with it with so many difficulties to manage, but making flexible working the default position. None of these have been, come into force yet. We expect the employment bill to be published in 2021. But of course, listening to HR for UK, we will be the first ones to keep you in line to make sure that you are aware of these changes as soon as they come into effect. So look out for these updates when the bill comes into effect. So before I move on to the furlough and COVID, I just want to have a look at. It is worth mentioning a case that has just come out of a judgment that has just come out of the Employment Appeal Court. It was actually in the Supreme Court, and this is around worker status. You may remember way back in December 2018, there was the case of the Uber drivers who were trying to get their status changed to that of a worker status, and they were successful. It's gone through the channels of the Court of Appeal and has finally come out with the Supreme Court having to look at what the sticky issue around worker status for those Uber drivers, because of course we know that if you are a worker, you are entitled to the national minimum wage. You are also entitled to paid annual leave. You get whistleblowing protection, and you have those rights as a worker. And of course, we know that this is, the Uber case was the poster child for the gig economy, and we know that there are a couple of other cases that are also waiting to be decided on slightly different points, but as soon as those decisions come out, we will let you know. But let's just have a quick look and a quick reminder about the key points that come out of the Uber case. This is when considering looking at worker status, you've got to look at a whole number of factors. It's not just what the document says. You've got to look at the reality of the relationship between the parties, and without carrying out a detailed analysis on the relationship, you will not be able to identify the true status of the worker. And it is very individual for each worker, for each organisation. It cannot be a one-size-fits-all. And of course, when you are looking at worker status, it is important for a number of reasons. One of them is obviously for employment rights, but also there are tax issues in relation to that status. So it's very important to make sure that you get it right. And of course, just as in this case, the drivers were found to be workers, and they were workers from the moment they switched on their apps, and were available for work in their area and to the time when they switched off their apps at the end of the day. That was when they were considered to be a worker. Of course, presumably that also applied that when they switched off to take a break, at that point they stopped being a worker, but as soon as they switched that app back on, they were then once again deemed to be a worker. So I think the key takeaway from that particular case is for businesses to ensure they look carefully at the working relationship to establish the worker status, rather than looking at what the document labels that working relationship to be. As I've already said, there are many factors that you need to take into account when you are looking at worker status. And, you know, of course, it goes without doubt, if you are in any doubt and you are unsure, give us a call and we'll be more than happy to have a look at what your relationship is, what your documentation is, and we will be able to give you a clear indication as to what that worker status should be. Another case that's come out in recent days is a stark warning and a reminder to employers to keep their equal opportunities, policies and training up to date. It is quite common for employers to provide employees with equal opportunities training, which generally underpins the culture as well as culture within the business, but really it is also there in relation to the prevention of discrimination taking place. The recent case, as I say, was a stark reminder that it is really important to make sure that such training is kept up to date. And this is true not just for equal opportunities training, but it is true for all training that you provide in your organisation. So this particular case was, was around a race discrimination claim, and the company in this particular case wanted to rely on the reasonable steps defence. So of course we all know that if you have a equals opportunity policy and you provide equal opportunities training during the course of the employment of an employee, that is it is a tick box exercise, but you have to go further than that. Having those policies and procedures in place is the starting point. Having that training is the starting point. But what you need to do is you need to make sure that if you are going to be relying on the reasonable steps defence, that you have in fact taken all reasonable steps to prevent an employee from committing a particular discriminatory act, such as, as I've already said, through training. So in this particular case, even though the company had put the individuals, the employee concerned who had committed the discriminatory act through training, both the Employment Tribunal and the appeal found the reasonable steps defence was not available to this company, even though they had training and even though they had the policy. And that was because the tribunal and the Employment Appeal Tribunal found that the training had become stale. It was out of date. And when the Employment Tribunal looked into this, they found that the training had been given over it was a year and 8 months before the racist comment had actually been made. The organisation accepted that those comments had been made, and a colleague who overheard the comments failed to report it to a manager. Once the managers became aware of it, they too failed to take steps to report the discrimination acts that had been taken. And once they had became aware of it, they did nothing. And this was a clear indication that actually, even though they had provided the training, the individuals concerned did not know what to do with that information. And it was for this reason that the tribunal found that it was stale, the training was stale. And it's a constant reminder that employers do need to make sure that you have to have a look at all your training that you have, make sure it's up to date, make sure that it is regularly reviewed, and make sure that you constantly put people on courses, provide that training so they know what they need to do. It may be something that you want to do as as an annual review, but do bear in mind that when you have new starters joining the organisation, as part of their onboarding process, that is what they need to be going through, as well as part of everything else that you do. The importance of this is, of course, you can prevent these things going further by making sure that you review everything that you have regularly. Make sure that it is up to date and the training is actually effective. But of course, this decision, presents another task for HR teams to get to grips with in 2021. But it's really important to make sure that you refresh and implement effective training on diversity and inclusion for all your employees. And of course, if you need any assistance with putting this training together, if you want to review your training that you have, or indeed you want to implement some training, do get in contact with us, because we do have the training that we will be able to help you and support you with, and do get in contact. And again, you can do that through our website, you can give us a call, or you can drop us an email. Right, I have reached the halfway mark. I have got 3 questions in the question box, and I'm just going to have a quick look, because they do seem to be furlough questions. And I'm just going to, Christine, I'm going to try and open up your question. Okay, so Christine, I'm going to pause. I'm going to put everybody's questions on hold, because I think I'm going to be able to answer those in the furlough questions. I didn't think I was going to get any questions in the employment law updates, because of course this is all new. All the questions come in the furlough. So let's crack on and let's take you through the latest furlough update, COVID-related employment issues, and how to handle them correctly. So, of course, we all know that we now have a 4-stage roadmap out of COVID restrictions, and the key dates for businesses have now been published. Just as a quick reminder, between the 8th of March and the 29th of March, the stay-at-home rule will end on the 29th of March, but that means that there are still restrictions in place. People should still work from home where they can. Travel and journeys should be minimised, and of course avoiding travel at the busiest times. So again, if you've got employees who are going to be using public transport, do bear that in mind if you are going to be requiring them to come back into the workplace. Of course, travel abroad remains prohibited, other than for a small number of permitted reasons. We know that the next key date that we have, that no earlier than the 12th of April, is the opening of non-essential retail, care premises and public buildings. Indoor leisure facilities will also reopen, but again, subject to very specific guidance. Most outdoor attractions and settings will also have specific guidance that they will need to follow. Self-contained accommodation where indoor facilities are not shared will be able to reopen, and of course hospitality venues will be able to serve people outdoors. I can see all those pubs opening, and hopefully on the 12th of April the sun will be shining and we'll all be out in that pub garden enjoying a nice opportunity to be outside. Of course, the next step is no earlier than the 17th of May. Most businesses at this point in time, except for those at the highest risks, will be able to reopen. All sectors, everybody across the board will still need to maintain those COVID secure guidance, which will need to remain in place. And to be honest, I think they will be in place for a long time to come. Indoor hospitality will be able to open, and other indoor locations, including indoor entertainment venues, will be able to reopen. And of course, we'll be able to have some larger performances and sporting venues will be able to start happening. And then of course the 4th stage, subject to of course meeting all the normal tests that the government has got in place, no earlier than the 21st of June, the government will complete its review on its decision on the social distancing, the 1 metre distancing rule. They will also review the requirement to wear face coverings, so it's the masks and other measures to see whether it will be appropriate to amend them or to lift them. More information about the guidance from working from home at this point will be lifted, but as I've said before, until this time, the work from home rule should apply if at all possible. So again, still, if your employees can work from home, they should continue to do so. But this roadmap gives organisations a clear roadmap as to when they will need to start implementing changes into this to their workplace to be able to start getting their workers to come back into the workplace. So let's have a look at the coronavirus job retention scheme, the fondly referred to furlough scheme. I have some great questions coming in, Linda. I'm about to answer your questions. So we know that the the coronavirus job retention scheme is due to continue until the 30th of April, but it is being reported that the Chancellor is going to extend that beyond the 30th of April. We don't know what that extension looks like because he's been keeping that very close to his chest, but this will be announced in the budget on Wednesday, the 3rd of March, so you haven't got long to wait. And by this extension, it will allow workers to remain on furlough into the summer before the scheme is phased out. This extension will be part of a package which will be providing continued measures to support businesses, which will also include business rates holidays for the retail, hospitality and leisure sectors, which were due to end on the 31st of March. So those dates will be extended. But as soon as we know what the extension to the furlough scheme looks like, we will be first to let you know and to send out that communication to you so that you are kept in the know as to what the scheme will look like. So just a couple of changes to the reference dates. So the reference dates that I'm referring to, of course, is the reference dates that refers to the amounts that an employer can claim under the coronavirus job retention scheme in respect of a furloughed worker whose pay is based on the reference salary. Of course, we cannot be referring to the reference salary of March and April 2020 because, of course, COVID had kicked in. So the claims reference period for your claims for March and April, this will now will remain as the reference period of what that individual earned in March and April of 2019 rather than March and April 2020. As I say, this change avoids the furlough workers' pay being significantly reduced because they were on furlough at the time when you were making that reference check. The same will apply to the usual hours of work. Of course, we know that in March and April of 2020, people weren't working, so the reference period for the reference month is now going to be March and April of 2019. And of course, as the scheme is going to extend, I anticipate that will naturally follow with the months in 2019 rather than 2020. So let's have a quick look at the claims and the amendments of deadlines. So there have been some changes on the dates where you can make your claims and when you need to make any amendments to that. So in respect, so this is your claims for February. You should have made your claim already, but you do still have an opportunity to make an amendment if there needs to be. But for March, so the February, so your payments, your claims for February would have been in relation to your January claims. Of course, February, your claim period, the deadline for that is now the 15th of March, and the amendment deadline is the 29th of March. For March claim period, the deadline for claims to be made is the 14th of April. An amendment to that claim, the amendment deadline is the 28th of April. And finally, at the moment, we've got it as April claim period. The deadline for this claim is the 14th of May, with amendments to those being the 28th of May. And of course, once we know what the Chancellor announces in terms of what the extension is going to look like, we will be able to share that with you, because I'm sure that those will also extend along the same lines. We do know, of course, that in December, the HMRC announced that they were going to be publishing those organisations who are making claims under the coronavirus job retention scheme, and the first publication came out in January. It is understood that from February, HMRC will be adding further details to that publication, which will include the value of the claim within bandings, but it will now also include company limited company registration numbers and also those of LLPs, so company numbers for registered companies and LLPs, should I say. And the reason for this is to, sort of make it transparent that employees can double check to see whether their employers have actually paid over the claims that they have made. And this is going to increase the scrutiny of employers using the coronavirus job retention scheme and to make sure that public funds are not being abused. But of course, employers can apply to not have their names published if they can demonstrate that in doing so would put their employees at serious risk of violence or intimidation of anyone associated to their organisation. So that's the coronavirus job retention scheme. I'm now going to be talking about something quite controversial, and that is, of course, the lateral flow testing program. So again, this is part of the government's plan in supporting businesses to get employees back into work. So as part of the government's new drive to increase workplace testing and catch those undetected cases of COVID-19, the number of employees required, so the eligibility criteria has been amended. You now only need 50 employees to be able to be eligible to participate in that workplace testing program. It used to be 250 employees, but as I say, that eligibility criteria has now dropped down quite significantly to only 50 employees. So for those of you who might be asking, what is workplace testing program? Perhaps you didn't know about it, but this is, as I say, this is to identify and detect those cases where people are not showing symptoms and to prevent that spread of COVID-19 without realizing you even have it. So the program is designed to reduce the chain of transmission of the virus in the workplace, because this is obviously a workplace program. And under the program, workplaces will remain open to be able to establish targeted on-site testing, enabling employers to apply those regular tests for employees. And again, a combination of the testing, continuing with the social distancing and other preventative measures that organisations may have implemented into their workplace should go so much further to prevent those outbreaks within the workplace. So again, just very quickly, what is the test? So employees will be given a lateral flow test, and this will produce a result within 30 minutes. And it will be done through the way that the normal test is done. But of course, these flow tests are less reliable than the normal tests. And of course, if an employee tests positive with the flow test, they must immediately go for the I'll try and pronounce this correctly, the polymerase chain reaction, the PCR COVID-19 test. I'll refer to it as the PCR because otherwise I'm going to be trying to put my teeth in all afternoon. And they will need to go for the PCR test immediately, and they will need to self-isolate until they receive a negative test result from the PCR test. So again, I talked about eligibility. You can register to join the workplace testing program, but you need to be registered in England. You need to employ more than 50 employees, and your employees must not be able to work from home, because of course the work from home rule still applies. So again, within the with the reduction down to 50 employees, this opens it up to small and medium-sized companies who will benefit from having this rapid testing to be able to, get their businesses back up and running, particularly those who, as I say, have not been able to continue operating because their employees cannot work from home. Are there any pitfalls for employers? Of course there are pitfalls. Regular testing in the workplace is far more intrusive than the social distancing measures and the other COVID secure measures that we have in place. So employers, will encounter issues, particularly if employees don't want to be tested. And again, it gives rise to, reasons why individuals don't want to take the test. Might be for religious reasons, medical reasons, or ethical reasons. And whilst adopting a workplace testing regime is a proportionate way of being able to protect the health and safety of your workers, in most cases, you will still need to consider individual employees' situations on a case-by-case basis, and you will need to be prepared to make exceptions and adjustments where necessary. Again, as an employer, you will need to consider the practical implications of a testing program. For example, where are employees going to wait while you are waiting for those test results to come back? Because of course we know the results take about half an hour. Where are they going to be sitting or waiting while you're waiting for those results? So practicalities you will also have to take into account and have a look at and see how you're going to deal with that. And of course, quite a key thing about all of this is that employers must be mindful that these test results will compromise personal data. And of course, this personal data is going to fall into the special category of personal data. And employers will need to take a data assessment, a data impact assessment to consider how they're going to minimize that data protection and minimizing that risk of holding data of this kind, because of course it is really personal. And you will need to make sure that you have steps and processes in place to make sure that you safeguard it. Communication, communicating with your staff, of course, is going to be critical in terms of, reducing that risk by implementing these, workplace test programs. There is a real risk that if you are going to be introducing this workplace test program, that employees might have a false sense of security to think that actually I don't need to comply as much with the COVID measures that you have in place in the workplace. So again, it's about communicating to make sure that those measures that you have in place will still apply, even though you are having that testing regime in place. So again, there's lots of things that you will need to consider, and of course, employers will continue to face the challenges, around COVID-19 and making sure that there is a safe workplace for a long time to come. And this is going to test our patience. I think a lot of our HR individuals are going to be looking at and be thinking, well, how are we going to have a look at that? So I'm doing really well. I've got 10 minutes left before we end of it, but I think the last topic that I really do want to cover before I go to those questions is let's have a quick look at the UK vaccine programme, because of course we've looked at workplace testing, but we now know that the UK vaccine programme is well on its way, and it promises the return to the workplace later in the year, where workers, millions of workers, have been working from home or have been on furlough, and the program is full steam ahead, but employers will still face some difficult decisions around that. So for example, will you be allowing your employees to take paid or unpaid time off to attend those all-important vaccination appointments, because of course they are going to happen during work time, and of course there is going to be limited opportunity to be able to arrange it outside of the working day. So you're going to, as an organisation, you're going to need to make a decision whether it's going to be paid or unpaid. There is also the question, highly controversial question, of whether the vaccine will be imposed on employees as a contractual requirement. And we've all seen the headlines of no jab, no job. But of course, you know, you need to, if you are going to adopt that kind of policy within your organization, you do need to be mindful of the risks that come with that. As I say, it is highly controversial whether it's to make it a contractual requirement for employees in your work, so existing employees. Of course, new workers coming to work for you will perhaps be subjected to different rules and requirements. But again, you need to be careful of those pitfalls. But again, whether you are going to force the fact that employees need to be vaccinated before they return into work, as I say, this could be quite controversial. But again, employers need to, you know, you will continue to face the issues around managing work from home. Even when the work from home, if you can, advice is lifted, because we're going to have this new sort of, you know, working pattern of flexible working arrangements is going to become the norm. But as a result of the pandemic, but how are you as an organisation going to manage that and keep that, you know, operational so that your business can still operate? So let's have a look at requiring employees to be vaccinated. At the moment, it's not commonplace for employment contracts to have an express right for employers to compel employees to have vaccination. And quite simply put, contracts of employment would not have had that, because we haven't had a pandemic for over 100 years. So you wouldn't have a contract of employment that has a specific express right for the employer to force employees to have that vaccination. So let's have a look at it as a starting point on how can you introduce this into your workplace. And the starting point would be for enforcing, you know, mandating the COVID-19 vaccination is to decide within your organisation whether it would be, whether the requirement would constitute a reasonable management instruction. Now, in practice, of course, the balancing act of what the organisation wants and needs and the employees' point of view, of course, is going to require some form of balance, because, of course, as a business, you want to make sure that you protect your business, but equally you need to respect individuals in relation to their fundamental freedoms and their rights within the workplace. So if you are going to start looking at making it mandatory and you want to start mandating that COVID-19 vaccination, relevant factors that we would recommend that you look at is have a look at the nature of the employee's role. Look at the location of where they are going to be working. Have a look at the level of interaction between work colleagues and the proximity of work with the public. Are they going to be engaged with the public? Because that will also be, you know, have a determining factor. Have a look at the risks. Identify through health and safety risk assessment what are those risks of not having those vaccinations, as well as what are the risks on having those vaccinations. Have a look at the specific legal duty relating to health and safety, because there will be different sectors that will have different requirements, and you may fall into a sector where it becomes mandatory and you will need to implement that within your organisation. Look at the level of business interruption that would be caused if there was an outbreak of COVID-19 in your workplace. I have talked about that in previous webinars where organisations have had to close with very little notice because there has been an outbreak. So again, when you are applying these factors, it's likely that employers will be able to establish that it is a reasonable management instruction to require their staff to be vaccinated. But like everything, you must go through and have that assessment, go through it, ask those questions before you just have a blanket approach to how you are going to approach it. Make sure that it is considered, make sure that you look at it and you can justify what that reasonable management instruction is, because of course we know that if you are going to be enforcing a reasonable management instruction, if an employee fails to follow that instruction, of course it could give rise to disciplinary action being taken as a result of it. But of course, I would urge employers who are considering mandating the COVID-19 vaccinations in their workforce, make sure you have that assessment, carefully assess it on an ongoing risk basis, and make sure that you get that balance right. Because of course, if you are going to be, as I said, taking disciplinary action as a result of it, we don't know what the tribunals are going to take as their approach on that, because we don't have any guidance on it. There is no case law that gives us an indication on what would be reasonable and what isn't, because again, at the moment, we simply don't know what approach that is going to be taken. Of course, we will continue with the implementing, of social distancing in the workplace, the use of personal protective equipment. And the approach that we would strongly recommend that employers take is an encouraging approach rather than making it a mandatory requirement. At this point in time, you would be far better off in developing those employee relations by engaging with your workforce, talking to them about the benefits of having it, and letting them have freedom of choice to be able to either take it up or not, rather be encouraging rather than enforcing. And again, when you're looking at that assessment, you might want to sort of think, well, actually, there are certain roles within the organisation that are at higher risk, in which case the requirement would be more suited to make sure that those individuals are vaccinated. But again, the risk assessment will continue. It's an ongoing thing. Don't think because you've carried out a risk assessment once, you don't need to go back. Go back, review your risk assessments, go back, review your COVID-19 risk assessment before you make any decisions. And of course, the process of introducing any such requirements, you must give the employee the appropriate opportunity to be able to come forward, ask questions, give them an opportunity to be able to raise their concerns or objections. And if they do raise concerns and objections, listen to what that individual has to say, because there may be some value in what they are saying and what you can do to be able to resolve that sort of issue. Of course, if you have established consultation processes or forums in place, or if you have a recognised trade union, don't forget, if you're going to be implementing any of these changes, you must make sure that you consult with those organisations. And again, questions around this is really down to having that open, honest relationship with your employees, rather than going in with a hard-nosed approach and forcing it. But of course, if you have that assessment carried out that you do need to take that approach, of course you can, but just be mindful of any pitfalls that may come out of it. Again, for global employers, you will need to have a look to tailor your approach, particularly, you may need to have a look at it on country-by-country basis. But you know what, going forward, the future, we don't know what the future is going to hold, but we fully anticipate that more and more employers are likely to incorporate the right to require vaccination as part of their standard contractual terms for new employees going forward. As I've already mentioned, employees who are refusing, you must give them the opportunity to share and raise their concerns as to why they don't want to be vaccinated, and you must consider those grounds for refusal in a fair way. Again, you want to be careful, and you want to be mindful of circumstances where you might need to apply the exception to the rule, because there are always exceptions to the rules. So, for example, there might be a medical condition or disability which would give rise to an exception for the vaccination rule. Of course, there is the religion and belief, which may, again, give rise to the exception. Maternity and pregnancy, and of course we have those all-important data protection implications in relation to health information that is going to be shared. So again, you need to have a look at those GDPR requirements. So I have done that in a whistle-stop tour, and of course I'm sure that there are lots of questions, and as I say, you know, 4 o'clock, I said I would be here until 4 o'clock. I'm going to whistle through the questions that we have. Hopefully I have answered those questions during the webinar today, but I am going to go back and answer those. But of course, if you do need to go, as I said, I won't be offended. These questions will be incorporated into a sheet, a Q&A sheet that will be circulated out to you during the course of next week. So let's have a quick look at those questions. So Linda, you were at the top of the list early on. Your first question is furlough likely to be extended? If so, for how long, and are there likely to be restrictions of who can continue to be on furlough? I did answer that in my webinar. We don't know for certain that it will be extended, but there certainly is an indication that in the announcement of the budget on Wednesday, the 3rd of March, that the Chancellor will be announcing his plans for an extension of the furlough scheme into the summer, which will be able to facilitate those people who can't come into work, certainly in line with the current 4-stage return to, the 4-stage roadmap back into work. The second question is, what has happened to the new work placement scheme for under 24-year-olds? You haven't heard anything. So that's absolutely, so for those of you who are not sure what I'm talking about, that is, of course, the government's Kickstart placement, the Kickstart scheme. Linda, we have got some good news coming your way, so we will be in touch with you about what the next steps are. But of course, anybody who is interested in finding out more information about the Kickstart scheme, how can it support your organisation, please do go to our website at www.hrforuk.com. Under our services, there is a Kickstart page there that you can go. It'll give you loads of information, but if you don't want to go looking for it, of course you can just drop us a line at info@hrforuk.com or give us a call and we'll send you that information over to you. So Linda, I hope that has answered your question. Dawn, your question is, if staff on national living wage does overtime in March but receives the pay in their April payroll, can the overtime be paid at the old national living wage or must it be paid at the new? So it will be at the time that the work was actually carried out. So it will be at the old, just because it's being paid during the April payroll, the overtime carried out will be under the old rate. So again, when you submit your information to your payroll provider, you will need to make sure that they are aware of that. And of course, the new rates for the living national minimum wage only kicks in from the 1st of April. So even though it's going to be in their April pay, it will be at the old rates. And I know I've gone around that in a roundabout way, but yes, it will be at their old rates. So we have another question from Christine. We have had a tranche of people who have just been notified that they are to shield. Of course, we've had loads of people ringing in asking about the shielding. Whose choice is it whether they work? You have a member of staff who says he would prefer to work if he can remain in the fortress alone, which is fine by me. So Christine, to answer that question, yes, there are going to be individuals who will have received a shielding letter. I think they have widened that shielding requirement. And of course, the recommendation is that those individuals should stay at home, work from home if they can. If they can't, they can go on furlough. But of course, from your question, it sounds like this particular individual would prefer to continue to come into work. So again, it's a personal choice. You can't not allow people to come into work, but what I will say is make sure you have those COVID risk assessment in place specific to that particular individual. Make sure that you put in measures in place to make sure that you can reduce the risk of that transmission of COVID-19. So Christine, hopefully I've answered your question. Babna, we've had an internet issue, so hopefully you've managed to get back. Don't worry, Babna, the recording will be sent out to you, so you won't have missed anything. You will be able to go back and listen to the webinar in your leisure, and of course you'll be able to get a copy of these questions, and of course some other questions who have also come into the advice team, which we will share out. Lisa, you had to leave us. That's absolutely fine. As I say, I know I go way beyond my allocated time, and those of you who are used to listening to these webinars will know that I am terrible at keeping to that 4 o'clock deadline. We have one last question that I'm going to answer, and this is another question from Linda. What about trades people who come into contact with employees? Do we have an obligation, responsibility to ask tradespeople if they have been vaccinated before they come? This is to protect employees. So again, asking the question about whether people have been vaccinated is it's regardless of whether they are a tradesperson, whether they are a contractor, or whether they are an employee. It's about personal data. You will have to have other measures in place to be able to ask that question without getting people to divulge personal information, which is, as I've already said, sensitive information. You may want to make sure that you have a policy in place on how you are going to be dealing with trades people who are going to be coming in. Of course, if you're using an organisation, the appropriate process to have is to engage with the organisation themselves to find out what their processes are before you allow someone in. Of course, if you're engaging on an individual contractor, you would be wanting to have that information as part of your package of information that you provide them. Again, it comes down to the freedoms of choice, whether people want to be vaccinated, whether they have had the opportunity to be vaccinated. What I will say, Linda, is make sure that you, whatever process you have in place, make sure that it is done fairly and appropriately. And if you want us to have a look at that process, of course, do come back and speak to us, and we'd be more than happy to help you put a policy and a procedure in place. So that comes to the end of the questions. As I say, I'm quite conscious that I've long past gone my 4 o'clock time slot. But of course, HR for UK are here to help you. Do contact us. We can help you with more than what you think is on the tin. But of course, I'm going to go through some of the things that we can help you with. Of course, if you've got payroll needs, do get in contact. We can help you with payroll queries. If you've got training needs that you're suddenly thinking as a result of today's webinar, actually, I need to review my training program. I need to have a look at my actual training material. Do get in contact with us. We are able to help you. Again, if you're thinking about getting some additional support for your organisation in the form of Kickstart, please do get in touch. We've got a fantastic, we are a registered gateway for the Kickstart, so we will be able to help you apply for that application, and we will be able to support you throughout the duration of that Kickstart, because it's not only about the Kickstart, it's also about you, helping you to make sure that we can help you. So, of course, for any confidential help and support, do reach out to us. As I say, you can contact us on our telephone number, which is 01455 444 222, or you can contact us by dropping us an email, which is info@hrforuk.com. Or if you are already on our website, you can complete our contact us form, and we will get back to you as quickly as we possibly can. So again, our next webinar will be Friday, the 26th of March, same time, same place. What I will be covering then will be the furlough changes, which we will know will be coming out as a result of the budget announcement on Wednesday. But I'm going to be having a guest speaker join me next time. I'm going to be having Linda Neville from Sanamente join me, and Linda Neville is really helping and supporting businesses dealing with staff who have got mental health issues due to COVID, being in that long-term lockdown, being in that long-term furlough, having a look at that and trying to help not only business owners, but also help business owners to help their employees to re-engage and come back into the workplace after being away for such a long time. Of course, we have our HR surgery with my colleague Rob Hobday. He will be with you on Wednesday, the 3rd of March at 11 a.m. Where he will be able to answer those all-important HR questions that you may have. And as I say, it doesn't have to be about today's webinar. I'm not too sure he will have his crystal ball out in terms of the budget. It might actually even be at the same time. I'm not sure what time the budget is going to be, but be rest assured, whatever implications will have an impact on you as a business owner or as an HR manager within your organization, HR for UK are here to be able to support you, and we will get that information to you as quickly as possible. That's it for me. Have a fantastic weekend. Thank you, as always, for giving up your time to listen to me. I do hope you have found today's webinar useful, informative, and helpful. But if we can help, do get in contact and we'll be able to support you. And again, if you have any ideas about webinars that you want me to cover, please do be in touch. That's it for me. Have a fantastic weekend. Have a brilliant Friday afternoon. And that's it for me. Bye for now.